It's not in the face! Thank you.
Hello and welcome to Hey, Not the Face with your host, John Nash, and your producer, me, Steffi Haynes. And today we are going to give you an update on the antitrust cases, the two new ones against the UFC. We're going to take a look at some PFL news. We're going to take a look at some One news. And maybe we will have a bonus question at the end. It all depends on time. But the way that you get access to all of this is to subscribe. So make sure you're doing that so you have access to every single bit of content we have. John, how the heck are you? Because you are back from Vegas. What was the weather like? How you feeling?
Weather was terrible. I don't feel that good. There was a lot. I walked to the courthouse and back, and it's a few blocks from where I was staying, and dust in the air. I got a cough now. It started out of nowhere. The weather was supposed to be good, and then it started raining. So I think a lot what we're going to do is I did a live cast right after the hearings, and a good portion of it didn't get recorded. Because, and I don't know if it's because the rain was coming down so hard or the sounds of these sirens coming by, because there was just some accident or something happened, sirens went by, and maybe because the noise, Substack doesn't record. I don't know how Substack even works, but we lost some, so we're gonna, you're gonna hear everything you probably missed that I did not report from the courthouse because everything turned out to be a disaster afterwards. Terrible weather.
And we'll probably get some clarity on some of the points John was trying to say while it was pouring buckets of rain around him.
I will note, and you pointed out, the sound quality was actually pretty good considering how terrible.
I told you.
I got to give Substack credit. I don't know what their noise cancellation is or what, or if it's my mic that's that good, but it was so insanely loud outside. I had to exit the court to record. And as soon as I stepped outside, it started coming down hard. Of course, they're doing construction everywhere around the courthouse, so I had to walk through the mud to get back to my hotel. It was coming down hard. And again, sirens left and right. It sounded like there was a terrorist attack or something for a moment. So it was loud as hell, and yet you hear none of that on the recording. So hats off to either that mic I have or Substack. Whatever one, it's amazing.
Yeah, it turned out really well, despite the fact that some of it was gone, and despite the fact that had to be unnerving to have all this happening around you and you're trying to record. So we figured that we would dive in a little bit here at the beginning and address the issues that John was trying to tell us about point by point. So first question, you went to this court hearing on Tuesday. Who showed up from both sides, plaintiff and defendant, and also who showed up from the media?
Well, a huge presence in the courtroom that day. Huge. Well, actually, from the attorneys, yes, there was at least 13 attorneys, 5 from the defendants and 8 for the plaintiffs. So a lot of billable hours there being collected. There also was 2 women were there, and I couldn't tell if they were personal, there in support of the named plaintiffs that were present, because the 2 of the named plaintiffs were present. Phil Davis and Misha Sirkinoff were both there. And I couldn't tell if the woman sitting behind them was in support of them or an attorney or a clerk. And there was another woman sitting on the defendant side that either was another attorney, but she wasn't sitting up with the other attorneys, or a clerk. And she was, me and I was really annoyed with this, and the other member of the media, the only other member of the media there with me, the only other person in the courtroom, Paul Gift, was there. Although technically he's no longer reporting on this. I guess he was just there in his own personal interest. He's not a member of the media anymore. But we were annoyed with this one lady because she had out her laptop, and there's a specific rule that you cannot have any electronic devices. And yet she's typing away, and me and Paul are trying to take notes on paper and trying to read these notes later and can't read our own handwriting. And yet she's allowed to type stuff up. So I thought that was incredibly unfair. So that was the presence. There was, me and Paul were the only members of the media. I guess, the good thing there's not many people in combat sports media who live in Vegas. And there was just a ton of attorneys collecting collecting their fees. And it's, I'm not surprised because I don't think many people really care that much about these cases, tell you the truth, except for our listeners. But it is a little somewhat surprising because I think people underestimate the importance of these cases. Lee, as much as there was some blowback for Lee because people thought it should have been a bigger case. They should have got a bigger settlement. There should have been some sort of injunctive relief, whatever. It's still basically the biggest payday in fighter history. I mean, more money will go out to the fighters this year than to UFC fighters from that settlement than what the entire roster gets paid this year. 60% of the earnings, the settlement was 60% of the total earnings fighters made during the class period. So this is the biggest increase in fighter pay we've ever seen was because of that settlement. And we have potentially the same for this next group of fighters. There's just depending on the outcome. And yet, the media, the fans, the fighters, very little interest in it.
Was Judge Boulware assigned to the Davis case?
Yes, he was. That news came out, I think, the day after the hearing, but they did bring it up during the case. Judge Boulware, the case was considered a related case to the other cases, and Judge Boulware got assigned to it. So now, just to keep people, so they can keep track of these cases, there was the original Lee class action case, Lee et al. V. Zuffa. That got settled. There's the ongoing Johnson case, the primary antitrust case. They want to make a class action ongoing right now. The one that they tried to settle last year and failed. There's the new cases, the Mikhail Serkinov, Misha Serkinov's real name, Mikhail Serkinov, v. Zuffa. That's ongoing. And now Davis, as in Phil Davis, v. Zuffa, is the final case that's been filed against the UFC. So all of them are going, which makes Judge Boulware has become, I guess, based on this, the Judge David Doty of the UFC. And if people aren't aware of Judge David Doty, he is the federal judge sitting in Minneapolis that hears all the labor issues involving the NFL.
All right. So sounds like Boulware's getting everything MMA from now on.
He might. He's become kind of the expert in the case. As they note in the related cases, he, as a federal judge, he has more experience involved in the UFC. He's more up to date because he's more informed, more knowledgeable. And so it's likely cases like this might be moved to him. He might be the guy to do all these cases going forward, which I'm not sure the UFC would be happy about, but I'm sure the fighters would. At least based on his previous record. Who knows? He might flip completely.
Now, during your live stream, you noted that there were several, I won't say problems. Let's just refer to them as issues right now. I feel like an issue isn't a full-blown problem yet. So I'm going to use the word issue. So what are the issues with the first case, the Serkinov case?
Well, first, a reminder that the Serkinov complaint, that is an attempt to address the class action waivers. So Serkinov filed a complaint that's identical to the Johnson v. Zuffa complaint. They want to make it an antitrust. They're accusing the UFC of abusing monopoly power, having a monopsony, underpaying fighters, all the same, except it asks for a different definition of of what the class members would be. And it was supposed to represent only those fighters that had signed arbitration agreements and or class action waivers. So the entire attempt is to address the problem of fighters that have signed class action waivers and technically can't take part in a class action. And so it should be noted, too, the plaintiffs pointed out they removed the request. They pulled off the request to enter a stipulation to have the Johnson class amended to change those definition of what are class members. So the defendants right now don't really even want to file Serkinov. There's questions of will Serkinov be filed as a separate complaint or not. And the reason for that is the problem with the statute of limitations. When you file an antitrust case, the statute of limitations for antitrust is 4 years. This complaint was filed on May 23rd, 2025, which means the case starts May 23rd, 2021. People should probably note and probably remember that Johnson v. Zuffa, named after Caden Johnson, that was filed back in 2021, which means it starts in 2017. It officially starts, the date that Johnson covers is July 1st, 2017, the day after Lee ends. So it's an ongoing case, starts July 1st, 2017 to now. That means the fighters that are in Cirkunov who are right now in Johnson, if they have these waivers and get moved up, they lose 4 years. And so all the fights that take place in those 4 years, they would not collect damages for. They would be hurt by this. And so that's the problem. Now, what the plaintiffs are hoping for, and the defendants suggested they might do this out of the kindness of their heart, apparently, is the defendants might agree to let Cirkunov start on July 1st, 2017. And we can give reasons why they might agree to that, but there's also many reasons why they wouldn't agree to that. And the reason why they might agree to that is because they're convinced that no matter what, there's going to be some complaint coming forward that's going to challenge the arbitration agreements. And, instead of giving a hard time and maybe getting the judge upset, let's just agree to it. But at the same time, from their point of view, it probably makes more sense to not agree to alter that starting point for Cirkunov, because it would benefit them to lose those 4 years, because then they were not up for the damages for those 4 years, and it would possibly slow the case down. So there's multiple solutions were discussed in the court, and this is where it gets a little confusing because they didn't really agree to any of them. One solution right now would be to keep the Cirkunov complaint as a separate complaint. And then when they open up discovery, we would get the discovery information, and Cirkunov would start arguing on behalf of against the arbitration agreement. So that's one. Keep Cirkunov as it is, keep Johnson as it is, kind of go forward from here, and we'll figure it out as we go along. Then the other option was to drop the Cirkunov complaint, get rid of it, and add Misha Cirkunov to the Johnson complaint, and he would represent the fighters that signed arbitration agreements. And so they would have one fighter on that complaint that had signed an arbitration agreement and class action waiver, and so he would have standing, Misha Cirkunov would have standing to represent them. And so that was one of the reasons the UFC has been arguing that the Cajun Johnson, Tristan Connolly, and CB Dalloway, the named plaintiffs on the Johnson complaint, cannot represent all the fighters right now, cannot do a class action, is because they don't have class action waivers, and you need commonality in a class action lawsuit. And so they're lacking the similarity to a bunch of other fighters, and so it can't be a class action. So adding him would allow it to go forward. And then what would happen is, again, they'd open discovery. They would get the information about the arbitration agreements and class action waivers. The information they're specifically looking for is, did the UFC use their market power and coerce fighters to sign these arbitration agreements? And then the plaintiffs are going to argue that that violates Nevada law and federal common law, and that's how they're going to attack it. And if they do it this route, then what would likely happen is that the plaintiffs would file a motion to intervene. They'd ask the judge to take Misha Cirkunov and all those with arbitration agreements, create a subclass, which would be a separate class action at that point. And that way the Johnson class could progress as it goes along. And while we determine the arbitration agreement separately, because that could take several years on its own. So that's option number 2, which is, already complex enough. Now, the third option is very similar to the second option, but you keep the Cirkunov complaint as a separate complaint, and then you have to find a new defendant who also signed the arbitration agreement and class action waivers, and attach him as another named plaintiff to the Johnson complaint, so he would serve the same function as Cirkunov does right now, that he would have standing for the Johnson complaint, but the Cirkunov complaint could continue on as it is to challenge the arbitration agreement. So hopefully that clears it up, because in the court, I got to be honest, everybody seemed a little confused themselves about that.
I have a question already.
Go ahead. I'll see if I can answer. I have my notepad here trying to keep track of all that stuff.
Okay, you said that there's 2 options for Cirkunov. They can either put him in the Johnson class and let him be the representative of the fighters, let him be the commonality fighter that would have signed the arbitration agreement, or they could draft in another named plaintiff who had signed the arbitration agreement so that he instead could be the commonality agent, so to speak. Which one of those would be easiest?
Well, no one knew for sure, at least based on the conversation we had in the court, we didn't know what would be the easiest. No, actually, there was three possibilities, because remember, the first one is keep it as it is. Circanoff separate and Johnson. That's a third. But all of them brought up questions, I think, about the speed factor, because the judge even pointed out he understands what they're trying to do. What they're trying to do is not get slowed down as we argue these arbitration agreements. So what's going to happen is the UFC, they're going to ask for discovery. They're going to then challenge these arbitration agreements. And then that might take a while just to challenge the arbitration agreements. And then there'll be appeal process. And as he mentioned, it will take several years probably to get a final determination on those arbitration agreements. And if the Johnson case has to come to a standstill, that's 2 to 4 years lost waiting for these arbitration agreements. So as he pointed out, the judge says, I understand what you're trying to do. What you're trying to do is determine the arbitration agreement and all the fighters who signed the arbitration agreement separately, why the Johnson case can progress so it does not come to a standstill. Now, which one does that the best? I don't know if they determined it in the hearing themselves. They were going back and forth for a little bit. I think it's going to be determined in the future. They have another hearing scheduled for August 28th. I think at that point we will know for sure which route they're going to go. But I do not know which would be the fastest route, which would be the best, because there are probably situations that pop up in each of them, considering the standing, considering what fighter, consider what's the route that they have to take. So I'm not sure. One thing I will say though, do they have another fighter that could, if they want to do the route of keeping Cirkunov separate and adding another fighter, then they have to find another fighter. And I'm not sure. You look at the fighters they've signed and how when they do these complaints. I'm not sure how many fighters they have in their back pocket to pull out in these cases. Talking to fighters and managers, I don't know many fighters that are gung-ho to volunteer. Although I will note, after the Lee class got a bonus for winning their lawsuit, I did notice some fighters on Twitter or privately complaining that they weren't asked to take part because I think they would have liked the bonus. So maybe there are a lot of fighters now thinking, you know what, I am willing to sign up because there's a bonus involved.
Let's talk about the Davis case now. There are also issues with that one as well. So break down for us what the problems in the Davis case are.
Yeah, that was a very confusing day. Let me flip my page to the Davis page as we got to discuss this. Trying to keep track of these notes. Davis, now you got to remember, Davis is going for injunctive relief. He is trying to address the potential problems about who has injunctive relief standing, and he's not representing UFC fighters. He's representing basically all non-UFC fighters who fought outside the UFC in North America or in the United States, I believe it is, from May 29, 2021 until today. Although it really isn't important, if fighters in that class or not, because they're not asking for damages. Again, they're going for just injunctive relief. The big problem with Davis is that who does he or who the fighters in his class have standing? The UFC made it clear they're going to challenge, they're going to file a motion to deny, claiming that they don't have standing in this case. For Davis, one of the problems might be, as we talked about previously, he's a member of the Lee class, which settled. The judge carved out that fighters can continue, that fighters can sue the Lee, can sue the UFC if they're part of the Johnson class. But other fighters that were part of the Lee class have released their claims on these, antitrust monopoly charges, violations of the Sherman Act charge, the Clayton Act, anything like that. They've released their claims, and so they cannot sue the UFC. And so the UFC might complain or might argue that Davis cannot sue because he is not a member of the Johnson class. Now, I'm sure the plaintiffs will argue that it's a related case. This is on behalf of something the judge asked them to do, and therefore he is, should be considered a Johnson class member. I'm not sure what's going to happen there, but depending on this case and depending on what the judge rules, this is another one where they might maybe have to get other plaintiffs named in this case. And again, do they have the fighters available for that? So they might have to find other fighters, just like Cirkunov. It's not. Maybe they'll agree to let Cirkunov go forward as is. Maybe they'll agree to let Davis go forward. But if they need other plaintiffs, that's something they might have to find. I don't know if they have them. They just might have a list of fighters ready to step forward. I'm not sure, but that's something to pay attention to, because if you don't have the plaintiffs of standing, you don't have a case. And if you don't have a case, all these things people are hoping happens won't happen.
Judge Boulware had some things to say about the defendants and discovery. I was really charged up when I heard you talking about this. So please break that down for everyone, because it's juicy.
Well, what the judge said is the plaintiffs have made some complaints with regard to the defendants not engaging in discovery, that they're not completing discovery. They're not taking part in discovery. They handed over a bunch of fighter contracts and other information, but then they stopped with the discovery process. From the defendant's point of view, is they stopped because they filed this motion that claims that the Johnson class can't be a class action because they don't have anybody with arbitration agreement class action waivers. And so the judge, now, he didn't ream the defendants. He didn't go after them for not taking part in discovery. So but he did warn them. He warned them specifically going forward that if there are problems with them handing over discovery, if they make arguments why they can't do discovery, if certain officials in the UFC or in Endeavor, TKO, that are supposed to hand over discovery refuse, then he's not going to be happy. So it was a preemptive warning of being displeased with them not being discovery. So going forward, they have to take part. He did warn too, is if officials, high-ranking officials in the TKO business empire who are supposed to hand over discovery do not, he is willing to call them into court, put them under oath, and ask them what the hell's going on, which I got to be honest, when I heard that, I'm like, I kind of hope it happens, because just for the pure spectacle of maybe an Ari Emanuel or Dana White or someone like that, or Hunter Campbell having to show up and argue why they haven't handed something over. I mean, I don't care if they're in the right or wrong. I just think the spectacle of it would be amazing, and it'd be worthwhile just for that, just for our pure entertainment out from us watching as witnesses.
Question, really fast.
Yes.
When would that happen? Would that happen on August 28th?
Well, he originally was going to set a deadline. Then he retracted the deadline because he think we all came to an agreement that we're going to go ahead with this in good faith. And so there doesn't have to be a deadline like in a month or two, which I think he was originally going to set. So now we're going to have a conference hearing, a status hearing in August 28th. And at that point, I guess if there are problems, he might bring that up again. Like, I'm going to start calling people in, but he didn't lay a hard deadline. He was a preemptive warning more than anything.
So with that being said, then let's say they didn't fully cooperate and another complaint was made during that 28th hearing, and he says, you know what, I'm going to put some people under oath, and he sets another hearing. Let's say it happens a month after that or sometime this year. How bad would that be for the broadcast rights deal negotiations?
Well, at that point, if it happens after August 28th, I got a feeling it'd be done by then, the broadcast rights. So I don't think it's going to impact that at all.
Okay.
And in fact, I don't know if any of this will impact the broadcast rights, because I think most people looking on from the outside imagine that this is going to be a long process, but we'll get to that towards the end. I think that I want to note something that might be a little different than, or might change people's opinions of how this is going to go. So anyways, though, that's the first part about discovery. Now, the judge warned them of consequences if they don't comply, but then the plaintiffs brought up problems regarding custodians of information, junior officers at TKO that they're unaware of who may be custodians of information, problems with the cell phones. And what I'll go through each of them. The cell phone problem is they asked for discovery. They got a list of everybody's phones, and they noted that that the discovery process is supposed to start back in 2017. That's the date they're looking for, and a lot of these phones are like new iPhones. And it's like, well, that means you haven't been preserving your information from before then, as you're supposed to do. Your attorney should have told you preserve information. You have not, because you have new phones. Where's the old phones? So the judge, the judge did say that he doesn't think that's that big a deal. You can't expect everybody to keep their old phones. and will have to get requests for the cloud services to get access to their text messages and stuff. Regarding junior officers, this was another interesting point, is that they listed top executives of Endeavor, but those are the people that we know deal with the UFC. There's a lot of junior executives that are often assigned a part to take care of certain things for TKO, but they're not listed anywhere as representatives or officials for TKO. So they don't know exactly at this point who else they have to get information from. So they're going to need someone to go through, either text messages or internal documents from TKO, and then find out like which officials have knowledge about TKO and which officials do we need more access to their messages. So there's that as well. And then there's a whole other matter of, Endeavor claiming that, that we're a separate company. And some of our community, I guess the plaintiffs are arguing that their concern is that TKO is going to be arguing that some of their, their cell phones and stuff they use were their private cell phones for business, and so they don't have access to that. And the judge kind of agreed that, it's common. You can't expect an executive to only use their business phone for the business material when they might get a phone call at night from someone else or a text message. So that seems a possibility. So there's a whole just going to be just a wealth of material that has to be shared. They're going to have to go through and figure out how much additional material might have to be shared with the plaintiffs. They're also going to have to find out if anything's missing. So this could get interesting. This might be boring as hell. Who knows? But it's a major part of the case because it's important for the plaintiffs to have as much access to information as they need from discovery. And hopefully that material hasn't been deleted or is being hid somewhere. And so that's the big argument now. How are we going to find all this material?
It seems to me like they compartmentalize a lot of stuff, don't they?
It's possible. They do make arguments that make you think that is this argument in good faith? Or are you just trying to argue in a way that says that, we're only going to hand over material, but not the real material that's being done by someone else at Endeavor outside the TKO company?
Yeah. All right. Let me ask you this. Do you feel like the plaintiffs did a good job considering all the confusion with the time limitations, statute of limitations, what have you, and identifying who can be in what class?
Well, I will say in their filings, yes, mostly they did a very good job. I think those filings, the complaints are very well organized. Although, again, there's, the stipulation and the starting date for Misha Serkinov is a big question. So you have to wonder, did they figure that out ahead of time or did they realize later? In the court, I don't know if I'd give them as high a grade because, and this is just not the plaintiffs, everybody was confused for long portions of the court hearing because there's so much material going on, so many discussions of possibilities that I think everybody got lost in what someone else was talking. The judge would be talking about one thing, the attorney would be talking about another thing. The defense attorney would step in and then he would say something that none of us understood what the fuck he was talking about. So that was a problem across the board. And I felt bad for everybody at times. So I will note, though, Paul Gipp noted this during the hearing, and I thought he was kind of right about the plaintiffs and about their filings and their arguments. And he noted how this is what attorneys who have been paid like act like. And what he meant, I should note, this is what attorneys who have been paid, this is how they act. That was his comment. And what he meant by that is when you've won a case, the previous case, Lee, when you're no longer facing loss of millions and millions of dollars that you put into the case and tens of thousands of free hours. I think it was total over 100,000 hours from all the firms. So just a tremendous amount of effort and money you put in that case, and you could potentially lose it if the case doesn't go your way. And you get this huge windfall. Now you're just full of energy and you are filing stuff left and right, and you're taking maybe some risks and going for the jugular at times. And so I think that's kind of what he pointed out. These are guys that are no longer concerned as they were before about, man, we really just lost our shirt on this case. To then, you know what, the previous case, we got rewarded. Let's go all out on this. And that's the way it felt in the court. So that's what I will say about the plaintiffs. I thought in that sense, they did seem like guys that were gung-ho to go forward.
Now, let's get your overall thoughts on everything that happened in the hearing, as in a generalized statement, however you want to do it.
Well, I mentioned already how little attention this is getting, considering and how important this actually is. I mean, it's not when I say important, and this is something I got to remind myself to bring up every time I talk about this case, is we talked about the Lee case, we would bring up the treble damages and that they're asking for $800 million to $1.6 billion. And people would get preoccupied with this monstrous, enormous number. And they would ignore usually the rest of my sentence after that, where I would start talking about, well, that's why it's very unlikely the UFC will go to trial. That's why they will settle, because the risk is so great. The same with the plaintiffs. The risk was so great because they put so much money and time into the case. And to go to trial and need to get 8 unanimous jurors meant that the plaintiffs were always going to settle too. And so I think the same reminds her, this case, people expect that this case will destroy the UFC. If you're worried about the case and you're a fan of the UFC, you're always like, oh, this case could destroy the UFC. And if you're pro fighter, you're always like, this case could just, could bankrupt the UFC and fighters could walk away wealthy for the rest of their life. Neither are likely, but at the same time, it's incredibly important. I mean, fighters don't have pension funds, and yet a bunch of fighters in the Lee class are going to be going home. Guys that maybe made $200,000 during the Lee period on 5 fights are going to be getting a check from one check instead of spread out over multiple fights, which they don't have to share with their trainer and managers. They're going to get a check for almost the same amount of what they got paid for those 5 fights. And so that's important for a lot of guys that don't have a lot of savings, that need to look forward to the rest of their life. Maybe pay off some medical debt, maybe down payment on a house, whatever. So this is very important to fighters. And it's very likely, based on what I saw in the hearing, and very likely based on how I know these cases work, that we might get another similar outcome, maybe even slightly better if everything works in the fighter's favor. So that's important. Fighters will get another check, and hopefully, depending on what happens in those arbitration agreements, hopefully every fighter will get some more money, will get some help going forward. And I'm going to admit how biased I am in this. You can argue that the UFC is not a monopoly, whatever. I just know they make a ton of money, and I would like to see the fighters have some sort of, some help going forward at this point. And I am biased on that front. I will admit that freely. But so I brought that up, that it is not getting that as much attention on that front as you would kind of expect, considering how this is probably the number one thing that could improve fighters' financial security. And also, I mean, and just a strange thought is maybe the reason John Jones is not gung-ho to come back and fight right away is because he knows he has a $6 million check coming to him. Right. Mm-hmm. That's what the Lee class did. The Lee case did. And on top of that, I also mentioned how they might need additional plaintiffs for standing. And so there's that overhang in this case, that if they don't have standing, all the fighters, if the cases don't have standing, then those results we got from Lee, the results that we're talking about that may happen for Johnson, are impossible, because you need plaintiffs that have standing. So that's another big thing. The last thing I want to mention that I thought is really important is how fast this case might go. The judge mentioned during it that Johnson might go to trial in 2 years. And I thought, well, man, that's really optimistic, right? But then I looked at the schedule, and if the judge keeps him on schedule, I think it is scheduled for class certification to be in 2027, which means the appeal would be immediately after that. And if it clears appeal, we should know it, no guarantee they get to class certification. But if they are granted class certification in 2 years, and the appeal goes like it did for the Lee case, where the Ninth Circuit heard it and rejected the appeal within a few months, we could have a trial set. It maybe not 2027, but 2028, 3 years from now. And maybe the judge is right. Maybe we can go even faster, and in 2027 we can have a trial. But that is much faster than I think people imagine this case could go. And he seems intent on, and part of why we wanted to see the arbitration agreements put in a separate track. And so Johnson is not slowed down. The judge seemed very interested in that concept. Let's keep this case moving forward. The other thing is Davis, based on mentions inside the court, there's a possibility Davis gets done even first before Johnson. That's the injunctive relief. And so, I think we looked at Lee, and based on who knows what curveballs are going to be thrown in this case, but we saw Lee take 10 years And we imagine that these cases will take 10 years as well. Although Johnson was filed in 2021, so it's already taken 4 years. But Sirkinoff and Davis are just filed. There's no guarantee, based on the judge's comments and the way people act in the court, I'm not sure that that time frame is accurate anymore. These cases might be much more rapid. I don't think people are ready for that. How fast this might go if the judge and the attorneys in the court or at least the plaintiffs, I know the defendants would like it to go as slow as hell. If what the plaintiffs and the judge were saying is accurate, then these cases might go faster than I think a lot of people are aware of.
Well, all right. So that is going to wrap up our section on the antitrust complaints that are happening right now. From here, we're going to move into the rest of our content for today, and we are going to start with the PFL because they had some big news this week. To access the bonus content of this episode, you must be a paid subscriber. To do that, go to heynottheface.substack.com and subscribe today.
Ow! Ow! Not the face! Ooh! Ooh! Okay, the face!